All right, well, let's talk about court. Now, for most people, court is the toughest part of the process. And the reality is court is tough. I mean, there's nothing like standing in front of a judge and being accused of a serious crime. And sometimes the unknown is a big part of the stress. So, well, let's clear some of it up and let's talk court. The first court date you will appear at, with very few exceptions, is called an arraignment. The arraignment is where you will be advised of the charge, the potential penalties associated with the charge, maximum and mandatory minimum penalties, your rights, and then you'll be asked to enter a plea, which is always not guilty. Then the judge will consider conditions of release. Conditions of release are essentially rules which you have to follow while the case is pending in order to stay out of trouble. Typical conditions for a DUI include do not drink or use non-prescribed drugs, including marijuana. Don't go to places where the primary business is the service of alcohol. In other words, don't go to bars. Stay out of trouble, do not commit any crimes, and appear back in court when you have to. Now, a quick word about these conditions. If you work at an establishment that serves alcohol, tell your attorney prior to the arraignment. It's important the judge permits you to go to your place of work in order to maintain employment. If this exception is not part of the judge's order, you will not be permitted to go to work. All right, well, look, there are times when a court will impose additional sanctions and penalties. These can include pretrial probation, which means you're on probation during the case, an ignition interlock device, a scram bracelet, or even bail. The court may impose such conditions if the facts of your case are particularly egregious, so in other words, a bad accident, a high breath or blood test, or if you have a prior DUI. Now, if you do have a prior DUI, you can expect, at least in the courts I'm in, pretrial probation, and in every court in the state, an ignition interlock device if the present and current case involves alcohol. An ignition interlock is mandatory, in fact, if you do have a prior DUI charge. If you don't have a vehicle to put the device in, well, then you'll need a scram bracelet instead. The next court date is called a pretrial. This court date is when a case can resolve or the case can be continued. A continuance is when we ask for more time so that we can gather more evidence, complete necessary tasks like an alcohol drug evaluation, prepare for motions or even a trial, and importantly, continue to negotiate the case. Now, depending on your case and the court you're in, it is likely you won't need to appear in court at a pretrial if you have an attorney. Now, this is true for all Whatcom County courts, including Whatcom County District Court and Bellingham Municipal Court, and all Skagit County courts, including Skagit County District Court. A motion hearing can be done for a variety of reasons, and depending on that reason, we might have some slight variations of the term. But to keep it easy and simple, I'm just calling this type of hearing a motion hearing. Okay, motion hearings are when we want to argue evidence in a case. Specifically, we want to try and suppress or remove evidence in your case. Successful motion hearings can remove or suppress evidence and even, in some cases, dismiss the case. Typical motion hearings might include a motion to suppress the breath test, blood test, the refusal of a breath or blood test, probable cause to arrest, or even the original contact of the defendant or stop of the vehicle. Probably the most common motion hearing, though, is to suppress statements made by the defendant. Certain motions, such as suppressing a breath test, does not dismiss a case, but removes the breath test, which would certainly improve the case. On the other hand, there are motions that are what we call dispositive, which means they can dispose of a case, so dismiss the case. Such motions that are dispositive would include a motion to suppress the original stop or contact of a person, or that there was no probable cause to arrest for DUI. If your case has been negotiated to a place that's acceptable and you want to enter a plea, well, you have to go back to court and enter that plea. But you just don't show up to court unprepared. Now, I can't speak for all attorneys, but the way I do it is to prepare for the plea with my client at least a day before court. And, of course, the day of court. When we appear in court, I always go over the plea with my client at least twice. The first time we go over a plea form is to ensure that my client understands what is in the plea form, what every paragraph means, the impact, of course, and the recommendations that are jointly agreed to. The second time we go over the plea form, I actually pretend I'm the judge, and I go over the plea form with my client exactly like a judge would. And the reason I do this is it prepares my clients for their appearance in front of the judge. Entering a plea is stressful, so my hope is that this removes a little bit of the stress from my clients. And importantly, the idea here is that there are no surprises. Surprises are not good. Now, after a plea, you may need to check in with probation. Of course, you may not need to, but that depends on the result of your case. But if you do, your attorney should prepare you for this. You may also need to check in with the court clerk to set up a payment plan if, in fact, it hasn't already been done so in court. If there's jail time or home detention time, you will also need to contact the appropriate agency to schedule this. Now, I won't spend too much time in this video talking about trial, as I think that should be a separate video and is probably overkill for this video. But here is a synopsis of what a DUI trial looks like. First, most DUI cases never even go to trial. Second, when we do go to trial, this means, at least to me, that we have not successfully negotiated the case to an acceptable result. This is usually a disappointment, as I really focus on negotiating a case to a vastly improved result. And I'll talk about that during the negotiation chapter. Third, if the case does go to trial, well, this is a big deal. Trials can be stressful and time-consuming. And the basic idea of a DUI trial is that the government must prove that you have committed the crime of DUI beyond a reasonable doubt. Again, I won't detail the trial process in this video too much, but the government presents their case based on permitted evidence, and the defense offers a defense, or alternatively, argues that the government has not proven their case beyond a reasonable doubt. The presentation of evidence starts with the government and their witnesses. Their witnesses would include the officer or officers that were involved in the case, perhaps civilian witnesses, and even experts, such as a BAC technician and toxicologist. Now, once the government has rested, in other words, have had all their witnesses testify, well, it's your turn, the defendant's turn. Defense witnesses may include you, the defendant, civilian witnesses, and even your own experts. Once the case and evidence has been presented, the attorneys make closing arguments, and then the jury decides your fate. As I said, a trial is usually, but not always, a last resort. If you believe you want to go to trial and you feel this way at the beginning of your case, be sure you discuss this process with the prospective attorney before you hire him or her. You want to know if your attorney is capable of taking your case to trial before you commit to hiring. Some attorneys don't even go to trial, while others might have a schedule issue or conflict at that time and may not be able to even do your trial in the next few months. And you need to know this before you hire the attorney. Negotiation is an integral part of every DUI case. The basic premise is rather straightforward. We want to negotiate to an improved result. We have to improve your case. Now, negotiation is a bit of an art form, which does sound a little bit pretentious, and honestly requires really years and years of practice to improve. For example, I'm a far better negotiator now than I was 25 years ago. Now, here are some of the things that I look for to help my clients with negotiation. First, and most importantly, the facts of your case. For example, if you were stopped because you had a headlight out, you were cooperative, and your BAC is, for example, around 0.09, then these facts support a reduction from DUI, presuming you have no prior DUI or related criminal history. On the other hand, if you're involved in the accident or had a child in the car or a firearm in the car, or you weren't cooperative, refused the breath test, or if your breath test was high, meaning over 0.15, it is likely that the government will be far less willing to consider a reduction from DUI. Second, criminal history. As I alluded to, if you have no criminal history, this makes negotiation far easier. If you have a prior DUI, well, this makes the case much harder to negotiate. I'm often asked if a prior DUI makes a case twice as hard to negotiate. No, it makes it 10 times more difficult to negotiate. Third, legal defenses. Okay, well, sometimes we do not have facts that help us. If your BAC is, for example, around 0.13 or higher, you will not get a simple reduction. That BAC is just too high in most courts for that desired reduction. Therefore, we need legal defenses. Now, there are many potential legal defenses, but we're looking for legal issues in, for example, the way you were contacted or stopped, probable cause to arrest, and the breath testing or blood process. If we're able to locate a solid legal defense, then we try and use this to negotiate your case to a better result. Okay, well, what if we don't have any good legal defenses? And yeah, this does happen a lot. Well, we just don't give up. Negotiating isn't just about finding something and then hoping it works. The truth is sometimes it doesn't work. And that's when we have to get creative. Now, this is probably a separate video, but in times like this, I try to barter with the prosecutor. Now, it might be giving up something to get something. So giving up something might be more jail, in other words, more home detention most likely, community service, or more probation. But whatever we can do to get a better result is worth exploring. However, and ultimately, it does have to make sense for you. Yet another important part of negotiating is telling a story. And this is part of every negotiation. Look, sometimes bad things happen to good people, and we want to share with the prosecutor important and compelling information about you. For example, have you had some difficult times recently? Or will this charge of DUI cause you severe consequences? Now, sometimes this information can make a difference in the outcome of your case, and honestly, sometimes it doesn't make any difference. But negotiating is about trying everything we can to get a better result, and you just never know. The human element can sometimes be the difference between success and failure, and is always worth trying. Okay, and finally, relationships. It is, at least in the smaller counties, so not King County perhaps, but most other counties, really important to have relationships with prosecutors. If the prosecutor knows your lawyer, trusts him or her, respects them, and even likes them, then the chance of a better deal is more real. Okay, well, now let's talk about penalties that might come from a DUI. And this is not the most enjoyable thing to talk about, but we need to. The amount of jail you get often depends on the facts of your case and your prior criminal history. If you have a prior DUI charge within 7 years, the penalties get severe. If you have 2 prior DUI charges within 7 years, well, things get even worse. Even if you have a DUI charge from 30 or 40 years ago, that will be used against you. Now, if you do have a prior DUI charge, please talk to your lawyer in more detail about this. All right. If the jail in your case is mandatory, and DUIs do come with mandatory jail, then it must be served in a jail. That being said, there are a couple of exceptions. First, you can convert jail to home detention, but the ratio isn't appealing. 1 day of jail that is mandatory can be converted to home detention on a 1:15 ratio. This means 1 day in jail is 15 days of home detention. Now, if you do get jail, you would need to report to the Jail Alternatives Office in Skagit County or the Jail Work Center in Whatcom County. In Skagit County, they have a great program that converts jail into their one-day offender program. However, this must be negotiated. The one-day offender program allows you to convert up to 2 days of jail. You would then serve the jail in a dormitory that's located on the Skagit County Fairgrounds. The Skagit County Sheriff's Office runs this program a few times a year, so you have to schedule your time in advance. Now, this isn't perfect, but I can tell you it's far better than going to jail. Work release is where you are actually in jail, but you're permitted to leave every day for work. Now, you should expect to have to tell your work that you're in the program and you're not able to drive when leaving the jail. So you'll need to have someone pick you up daily. Home detention is where you serve your jail time at home. If you work, you are permitted to leave your home and go to work, and then return at the end of the day. The government-run home detention program in Whatcom County is pretty limiting in that you only qualify if you both work and live in Whatcom County. FDS stands for Friendship Diversion Services and is home detention. The difference is it's run by a private agency, and therefore there is more flexibility than the government-run agencies. FDS is used in some courts in Whatcom County, but not in Skagit County. Work crew is used in Whatcom County quite a bit and might be used in lieu of jail if the jail isn't mandatory. Work crew is usually manual labor and involves yard work in parks like raking leaves, mowing lawns, or picking up garbage in local parks or alongside highways. Community service can be negotiated with prosecutors in lieu of jail, but honestly, we don't seem to see a lot of community service in DUI cases. A scram bracelet is an ankle device that detects alcohol consumption through sweat glands. These devices may be ordered at your first court date if the facts of your case are extreme or if you have prior DUIs. In my jurisdiction's Bellingham Municipal Court loves scram bracelets, so be duly aware. If you're convicted of DUI or reckless driving in the court system, you will lose your license. The court does not suspend your license, but sends information regarding the conviction to the DOL. The DOL then suspends your license, and you'll receive confirmation of the suspension approximately 2 weeks after your plea. The suspension will likely not occur until around 45 days or so after the final court date. If you had a Department of Licensing hearing and lost, you will receive credit for the time you've already served. All right, I do spend a lot of time talking about reducing a DUI throughout this video, so I think it's appropriate I talk about the most common reductions from DUI. And I won't talk too much about what a DUI is and how the state needs to prove it and so forth. That's actually for a different video. But suffice to say, a DUI can be proven if the defendant has a blood alcohol concentration of 0.080 or higher within 2 hours of driving. And this is called, by the way, a per se DUI. Or if the defendant has 5 or more nanograms of THC, which is marijuana, within 2 hours of driving, or if the defendant is impaired by alcohol, drugs, or a combination of alcohol or drugs. Reckless driving is a common reduction from DUI. And like a DUI, it's also a gross misdemeanor. But unlike a DUI, it has far fewer penalties. In fact, the only penalty that is mandatory with reckless driving is a 30-day license suspension. Negligent driving first degree is even better than reckless driving. Neg 1, as we call it, is a simple misdemeanor and has no mandatory penalties. Do you want your DUI and every accompanying charge to be dismissed? Do you want to avoid all jail time and home detention? And do you want to save your license from suspension if you gave a breath or blood test? Well, you can. You can do all of these things, in fact, if you successfully enter and complete the deferred prosecution program. Deferred prosecution permits those who are alcohol or drug dependent or suffer from mental health issues to enter into a 2-year treatment program in exchange for a complete dismissal of the charge or charges in 5 years. Also, this results in no jail and no loss of license if you gave a breath or blood test. The deferred prosecution statute allows you to petition or ask the court for a deferral or postponement of your case for a period of 5 years while you seek treatment for your dependency problem. If you petition the court and it's granted, the advantages are obvious. You keep your license, avoid a conviction, avoid being fined, and except for cases of where those charged refused the breath or blood test, avoid an administrative license suspension. To qualify for deferred prosecution, you must obtain an evaluation from a state-approved treatment agency. The treatment facility will conduct a detailed assessment, and if it concludes that the criminal conduct was the result of alcoholism, drug addiction, or mental health problems, and that you're amenable to treatment, meaning that you're serious about treatment and willing to be treated, you are eligible for deferred prosecution. Presuming that you've never been granted a deferred prosecution before. You're only permitted one deferred prosecution per lifetime. Now, if you're considering entering into the deferred prosecution program in Washington, it's critical that you and your attorney be familiar with the court where the petition or deferred prosecution will be entered. The program consists of a required 2-year treatment program, which is broken down to a demanding 3-phase schedule. The first phase is typically 3 nights per week for the first 2 or 3 months. Phase 2 involves 1 meeting a week for a 6-month period. Phase 3, which is the least rigorous of the 3 phases, requires counseling once a month for the balance of the 2-year program. You'll also be required to attend 2 self-help meetings, like Alcoholics Anonymous, for 2 years. Those who choose the deferred prosecution option are then placed on supervised probation, which requires a monthly meeting with the probation officer. Additionally, an ignition interlock device will be required for at least a 1-year period. If you submitted to a breath or blood test, a deferred prosecution will save your driver's license. Now, if you do everything correctly, your DUI and any accompanying charge will be dismissed 5 years from the date of entry, or 3 years after treatment has concluded, whichever is longer. If you are considering doing the deferred prosecution program, you should take it seriously, obviously. This program is not for the faint of heart, and failure will bring dire consequences as the court demands strict compliance. Okay, a couple of recommendations. Talk this through in detail with your lawyer. Similarly, talk this over thoroughly with your loved ones. And also weigh up the benefits and the burdens. If the burdens, for example, are more than the benefits, don't do it. And if the opposite is true, that is, the benefits are bigger than the burdens, then perhaps this is the right program for you. Now, there are some things that you will be required to do during your case that are very important. These include an alcohol drug evaluation, the possibility of alcohol or drug treatment, an ADIS class, and the DUI Victim Impact Panel. I also advise my clients to complete these requirements prior to the conclusion of the case, as it may help improve the case. However, you should only proceed with these after consulting and being counseled by your own attorney. An alcohol drug evaluation is a structured assessment used to determine an individual's substance use history, patterns, and potential impact on their life. It typically involves a clinical interview, standardized screening tools, and biological testing. In other words, a urinalysis. Following the evaluation, the treatment counselor will provide a diagnosis. The diagnosis will determine if you have no significant problem, the potential for abuse, or a significant problem with a substance that requires treatment. The Alcohol Drug Information School, also known as the ADIS class, is an educational program designed for individuals with substance-related offenses or concerns. It covers the effects of alcohol and drugs, legal consequences, and responsible decision-making. Alcohol and drug treatment is a structured program designed to help individuals overcome substance use disorders. It might include detox, counseling, behavioral therapies, and support groups offered inpatient or outpatient settings. Treatment addresses physical, psychological, and emotional aspects of addiction, aiming for recovery, relapse prevention, and long-term sobriety. The DUI Victim Impact Panel is a program where individuals hear firsthand accounts from victims or their families about the consequences of impaired driving. It aims to increase awareness, promote accountability, and reduce repeat offenders through emotional, real-life testimony. Probation is very important, and if at all possible, best to be avoided. Let's talk probation. Probation usually follows the completion of the case. Now, there are two types of probation, active or supervised. They're the same thing. This is when you report directly to a probation officer, are subject to random urinalysis testing, and you'll pay a lot of money for this privilege. Right now, that amount is as much as $100 per month. The other is inactive, or also called unsupervised probation. This is when you do not report to a probation officer, are not subject to urinalysis random testing, and you will pay much less, at least in Whatcom County, or you'll pay nothing, as in the case in Skagit County. Now, I take the negotiation of probation very seriously, and any way we can possibly reduce probation is worth exploring. Okay, here are a few tips when preparing for or dealing with probation. First, follow the direction of your attorney during the case, and what I'm really referring to here is the completion of an alcohol-drug evaluation, the recommended treatment or classes, and the DUI Victim Impact Panel. In many courts, the completion of these required tasks will allow us to negotiate unsupervised probation. Now, if you are on probation, do everything you can to make the probation officer happy. If they're happy, you're happy. Do not miss meetings, do not drink or use drugs, and remember, they will be testing randomly. So be careful of that, and also do not commit any new crimes. And if you do all of these things, you should be fine with probation. Now, what if you miss a meeting, admit to consuming alcohol or drugs, or test positive for these things, have a positive ignition interlock device reading, or are charged with a new criminal offense? Well, clearly this is not very good. However, if any of these alleged violations occur, the first thing you should do is call your attorney. Do not wait until the last minute to do this. But if any of the violations are alleged, you'll be heading back to court and you'll need to address these issues with the judge. If you're convicted of DUI, some violations are very serious. For instance, if you drive without valid insurance, without a valid driver's license, or drive without an ignition interlock device when you're required to have one, the mandatory penalty, if you were convicted of DUI, is 30 days of confinement. Yes, 30 days confinement does mean jail.